All right, everybody, thank you for hanging on there. We're going to go ahead and get started here today. So I apologize, our video is off today. We're looking into that problem, but we're going to go ahead and have a great webinar for you guys anyways. So welcome to 2026. It still feels weird to say that, but we have one of our favorite guests here today. This is David Smith, who is one of our featured guests. So just going over a couple of housekeeping things here. Thank you so much for attending. Please submit any questions that you have up in the chat box. We have some team members here who will pipe in and make sure that any questions you throw up will be answered. And if we don't get to your questions now, we'll email those out to everybody and email those answers around. Our standard disclaimer: this is educational and does not constitute and may not be construed as legal or tax advice. These materials change frequently and are subject to change, so please make sure that you verify anything after today, because as you'll see, a lot of this stuff is a moving target. So here I am. My name is Jason Karn. I'm your Chief Compliance Officer at Total HIPAA. If you guys have any questions, you can always reach out to us on our website, and if you need help with your HIPAA compliance, you can always schedule a clarity call with us, and we can walk through where you currently are and what you're working on. And as I stated earlier, I'm getting through this quickly because I know David's got a lot to say, and I want to make sure we have plenty of time to go through all the items that we have today. This is David Smith. He's one of our favorite speakers here. He's also been an integral part in helping us develop the Total HIPAA tool and the documentation that we use, and always a fun conversation here to talk about HIPAA compliance and what to look forward to in 2026. So David, welcome, and thank you so much for joining us here today.
Glad to do it, Jason. I was sitting here thinking about the times we used to do this in the office with mics, and how much that was all pre-COVID, how much the world changed in terms of being able to do things virtually. So
yeah, it's fascinating, isn't it? It's a wild. It's amazing how much things have changed. Some things for the better. It's nice to commute from home, but it's also it's tough because we don't get to see each other in person as much as we used to. So I thought where we could get started here is talking about major case enforcement, looking at the difference between 2024 and 2025. David, we were chatting about this a little bit earlier. Though the total amount went down as far as financial, the number went up as far as resolutions. For me, the interesting thing was some of the smaller fines and fees that we saw coming out of this. There was three, just looking at it roughly, there were three around $25,000, and there was one for $10,000, showing us that smaller groups, I think, really need to be careful and realize they're not going to get away with it like they used to think they would.
Yeah, I mean, I would think one of the things that's happening, again, it's not politics as much as it is just like one of those things that we see happen depending on who's in the White House. Oftentimes a lot of regulatory enforcement is about making an example out of somebody. But how you ultimately punish the group, having a big fine certainly gets a lot of headlines. But I think if you're a business, sometimes some of the, plans that have to be followed, the, corrective action plans and other steps that are required for that employer to comply, sometimes can actually be more expensive than if they just paid a monetary penalty. And I think what we're starting to see is more that mindset out of HHS, and they've just recently gotten somebody, back in that job within OCR, or nominated somebody for the OCR job rather. And, who knows how that will change or uptick. I'd also say the other things that have happened on this front is there haven't been any of the huge cases that were, as much of a ringing in the ears in the last 12 months like there have been in prior years. And I just think for us, it's not that people have gotten better about it. Here's the thing that I'm finding with privacy and security related issues is people being aware of it does not mean that people aren't still ignoring it. Or even the people that have tried to do their best about it are having more oops than they thought they were going to. And so I would say, as much as something becomes in the public eye and visible, you're going to see a strong reaction regardless of who's in charge of the administration. And I think 25 probably reflects more the attempt to try and find resolution rather than the big penalties. But the second somebody majorly screws up, there's going to be a big deal.
Right. Well, and I think also something else we were talking about before we got on here was still the looking for corrective actions, looking for, let's get a resolution maybe that isn't public, to just make sure we're getting things done properly before we get to the fines and the penalties and into that phase.
Yeah, undoubtedly. And I think along that line, it is the story I used with somebody recently to explain this is one time I got stopped for speeding, which I know is shocking to hear. And the officer, when he pulled me over because of my background, knew I was unlikely to actually have to pay that parking ticket or that speeding ticket.
Right.
And so his approach instead was to make me sit on the side of the road for 45 minutes talking to him. And then ultimately just gave me a warning ticket and said, slow down out there. You don't need to be, need to be mindful about what you're doing, blah, blah, blah. And it was funny in the aftermath because it was, that 45 minutes on the side of the road talking to him and being late for what I was headed to, and not being able to get anything done during that 45 minutes was actually a more significant financial penalty to me than it would have been had I just even paid for a speeding ticket. And so I do think that mindset of, hey, just do things right. We understand mistakes are made, et cetera, is an important message, but it also becomes a warning to people too, because we've seen a couple of these situations where people got told, this is what you need to do and how you fix it, and then they turn around and make the same mistake again. And usually there's not as much kindness the second time.
Right. Yeah, the audits that we've been a part of with HHS have been interesting in that, once you've laid out a lot of the items and if you've done the risk assessment and you've updated that, usually once we have a issue that comes up, we have our clients redo their risk assessments right away, so that we make sure that we've analyzed where the issue happened and that we've shown that we've made steps to correct that, getting those policies and procedures and those training records. And if you have that history, those things tend to go away pretty quickly because you're showing, hey, we made a good faith effort in doing this. So this is, yeah. So that's great. So we just saw actually here, and this is very timely, we just saw from OCR a release about what their focuses are coming up on 2026. So we put a lot of, and surprisingly, I think here about, some of the changes that they're looking to do, what we're looking for here in 2026. So I think the interesting one is really about the cybersecurity and system hardening, from an IT standpoint is, looking at those vulnerability scans and making sure that we've done those routine risk analysis assessments, as they use those words interchangeably there. And then getting rid of some of the addressable items. I don't know if you could talk a little bit about some of these updates and these changes.
Well, I mean, what I would tell you is that a lot of these issues go back to what I said a minute ago, which is people did the right thing, but they've not done anything to maintain it or to verify that they're still maintaining it. And so a lot of these, and I think about some recent examples of where there was, either a ransom event or there was a breach that could have been discovered. And, the party holding the information's reaction was, well, we've done all the work. We've done the training. We've done the policies. We've done the risk assessment. But, this one just slipped through the cracks. And it's that slipping through the cracks problem that I think people are just not being mindful about what their broader responsibilities are. You've got to recognize that it's kind of like owning a car. You go through the process of deciding what the right car is, and you go out and you price it, and you decide what the cost of maintenance is and everything else. And then you don't change the oil.
Mm-hmm.
And then you complain when the car breaks down because you never change the oil, because the car needs oil to operate. And
Right.
this hardening and cybersecurity reviews is so important because things change. We insert a new variable every day into a system, whether it's a new laptop, whether it's a replacement of a hard drive, and making sure that everything's compliant is just obvious and necessary to avoid the kinds of mistakes that are inevitably going to happen. And
Right.
that's why, doing the system hardening stuff is becoming so obvious. And I had this conversation actually with somebody earlier today where it's like, hey, you're going to encrypt a hard drive on your laptop. Great. Make sure when you buy a new laptop that you encrypt it before you put anything on it, because it does not
Right.
necessarily come encrypted. I mean, those are all things that seem obvious, but 9 times out of 10, the mistakes are being made because they've got good policies, just nobody's verifying that they're actually being followed.
Right, right. And that's, I think, a really important key because, as we're seeing this with, this cybersecurity hardening and what HHS says they're going to start looking for in the audits they're doing, and especially there at the bottom, we'll talk a little bit more about the audit program revival that we've seen some rumblings about, is making sure that we have active vulnerability scanning, that we're actively looking at these systems, because just saying, hey, we set it up once and we forgot about it isn't going to be sufficient. We've really got to have people or automated systems looking at these and making sure, flagging stuff for us.
Yeah, absolutely.
Yeah. The interesting thing here too is this mandatory use of MFA, or you can actually get away with using pass keys with that since it's got MFA built in. But that's one of the items that we really harp on. I think I've been harping on for at least 5 years about using and pushing people to really go that direction. So now seeing that coming out of HHS, OCR saying, hey, we've got to do this. Just adds that extra layer of security on top of everything else that you have. And then the comprehensive, the strict documentation, those asset inventories, those are that's some interesting. I mean, that's something that you should have anyways, but something they're really pushing on now and making sure that people know what they have and where it is. And we see that
I think
too.
each of these are becoming, I'd say all 3 of those issues together, MFA, which means multi-factor authentication for people who don't think like us.
Right.
The encryption, and each of these 3 are important because, things change and IT people do things they don't necessarily tell you about until it's too late. So, hey, our server farm was here, now it's here. And what that means now is, we've got to make some changes in terms of what are the protections, or we change the vendor. Nobody's done that. So the strict documentation goes back to the system hardening and just kind of the constant testing of making sure that you're staying compliant. That encryption of EPHI one, though, really has hit home recently to me because, like, my agency was acquired by somebody else, and so I know that our old Office and Outlook approach scanned attachments and automatically encrypted emails that had any EPHI in them. And then someone recently told me, like, nope, it doesn't work like that anymore. You've got to put bracket encrypt in bracket inside of the subject line. Otherwise, it's not going to automatically encrypt anything. And so making sure that people are aware of the changes and what that means in terms of their process are just simply good, straightforward approaches to avoid a problem down the road. Because again, in each of those situations, you don't have a problem with multi-factor authentication until you have a problem with it. You have a problem about encryption until something's come up and now you've got a breach. And you don't have a documentation issue until you realize you didn't document something, and that's going to create a problem for you. And it's just the little things that people need to be more mindful rather than just assuming that it's going to work. And this goes back to the one thing I feel like we harp on every time we talk, which is the privacy and or the security officer needs to take that responsibility very seriously. and they can't afford to just say, oh, it's done, I don't have to worry about it, let me look through all this again. That once a year deal probably isn't good enough, because how many laptops did you buy in the last 12 months? How many times you buy, or did your IT vendor, your backup vendor, change hard drives in their server farm? How many times did your software setup within Outlook change? Or the old tool that you used to do expired and you haven't got anything new because you upgraded to Windows 11 on everything. These are all areas that just seem obvious, and the place where the privacy security officer really should be doing their job.
Right. And you bring up a really good point around this, that I didn't put in here, but I think bringing up with your for example, with your agency being brought up, is what programs aren't being used anymore, and could there be PHI still within those programs? And so making sure you're doing adequate retiring, that you're making sure that you purge that information, that you've requested anything back from the business associates that you need to, that you're no longer using, that you've done those exit checklists and you've terminated those accesses for not only individuals but for business associates and programs that may have previously had that access, and the programs you may have used, because that's a really interesting, can be an interesting and potentially huge vulnerability if you haven't properly retired those programs.
Yeah, absolutely.
Yeah. So one thing that we threw in here was about the removal of special reproductive right protections, and I know that was a big push in the end of last year, but now we've turned around. I wonder if you could talk a little bit more about that and what that means for folks.
Yeah, again, things change when the White House changes, and the Biden administration on the way out the door had put in place special HIPAA protections for women's reproductive rights information. And so they were requiring providers to protect that information. A lot of it was related to acts by different states to criminalize, issues related to reproductive rights, not commenting on the political side of that. But the Biden administration was trying to put in place protections within the scope of HIPAA that said you've got to take necessary steps to ensure that you don't disclose to law enforcement agencies anything about reproductive rights, and that providers, et cetera, needed to take that and make that within the scope of HIPAA. So a couple of things happened. There were court decisions that struck down that particular requirement within the regulation because they said it was outside the scope of what HIPAA was intended to protect. And then ultimately, the Trump administration, once they came into office, took action to reduce or to eliminate that particular rule or its enforcement on a going forward basis. And so, there was a big discussion, I think when we did this January of last year, about this topic and that needs to do it. And then by June, the rules had changed. And I actually remember kind of a back and forth we had about the scope of that. And that, hey, what does this really mean? What employers really need to do? What do providers need to do? And ultimately, once there was clear guidance from the Trump administration, we realized we can just take it completely off the table. So that's the way it stands today.
Okay. So yeah, we basically reverted back to our so this of course it's changed that protection, but it's reverted us back to our 2025 stance of, while this is still protected health information, this doesn't have these special rights and protections that were given there. Okay. Another interesting update is this right to an access initiative. This has been a huge enforcement. This is a big enforcement piece for the first Trump administration about rights to access. I think it's important to talk about that. If you don't mind just chatting a little bit about what the individual's right to access is and the shortening of that time frame.
Right. So the reason that this issue's come up is because HIPAA and particularly HIPAA regulations were really designed to ensure on the security side and even on the privacy side that patients had the right to access their information. And this was put in place largely because people want to make sure their HIPAA record, their medical records were accurate, reflected what was really going on with them personally, and to also allow them to limit access to the information within that scope of that record. But ultimately, the real core of this issue came down to a number of medical providers were slow playing or not providing complete medical records, sometimes in reaction to the potential of litigation. So, for example, that provider might have, something might have happened in the scope of their treatment of an individual, and so they're now seeking their medical records because they want to determine whether or not there was medical malpractice. And so you had early on efforts by providers to charge money for people for the paper copies. Then once paper stopped becoming in vogue and electronic records were available, then they were literally slow playing access to those records. In addition, some of those records were also being restricted because of providers and even some payers wanting to not allow people to see what was being billed, charged, and paid for a particular course of treatment as well. And so for the Trump administration, both of these are what I'd call more big picture libertarian kind of mentality of we want people to have access to their information, and we need to eliminate or minimize the number of restrictions or barriers to being able to get their information in a timely way. And so the the right to access initiative rather was really launched to say, hey, you can't slow play this information anymore. When people ask for it, you got to give it to them. And if you are slow playing it, then we're going to view that as a violation of HIPAA. And I think at one level, it seems very logical. And so the question I'll often get from people is like, well, why is this even necessary? And the easy answer to that question is because honestly, sometimes providers just don't want people to have access to it.
Right.
And so they're not doing it quickly or in a timely way. And that's creating problems for the people who need the information. And so I think this is going to be a big push because, from the big picture political perspective, it's very much that, hey, we're just trying to give people what's theirs, and we're going to look out for the little guy to make sure that they actually can get their information. And so what I've said is, if somebody makes a request for information, provide it. Don't stand in the way, and make sure you're giving them a complete record as well, because anytime they can find that you didn't provide a complete record, then that will become a problem for you as well.
Now, you may have spoke about this, but maybe I missed this. But one of the sides too is, and correct me if I'm wrong, or maybe I should ask this as a question: what if the individual has not paid? So for the provider, they have not paid in full. Are they still able to get access to their record and get their full record from that say physician or from that provider?
I don't know of any restriction on that front, but hold on a second. So according to the guidance, no, they can't withhold it because the fact that they haven't paid the bill doesn't mean that they can hold on to their medical records, as basically ransom for getting paid. Right. So, there's a pretty clear Q&A on that front. To me, it's always, why would you not give the information? And there's almost always a reason for it. And it's almost always tied back to, some other potential piece of litigation or this information they just don't want to release. Okay.
Yeah, that's why I thought the guidance was back in the day. So I just wanted to make sure we reiterate that if the individual is not fully paid up, we still need to release those records within a timely manner. There are other ways to go and get paid versus holding records over their head or ransom.
Yeah.
Talk to us a little bit about this new enforcement. This is kind of new and interesting news that this would be the third in the series of our last time we did any audits was back. We had some OCR driven audits back in what, 2016, 2017. So
Yeah.
what's the rumbling you're hearing out there in the ether around audits in 2026?
Well, it's one of those things that's interesting where oftentimes audits are being done in anticipation of additional congressional action. And so
Mhm.
they're auditing people to figure out what people are not doing well. So then they can come back and change the rules, usually to tighten them to say, hey, when we audited these 30 groups, 29 had not done this. And so we need to do something to stiffen the penalty on this particular thing.
Mhm.
I think the forefront of this has been, in part to your exact point, which is it's been a while,
Mhm.
since something like this was done. And so are we better off instead of making broad? Because one of the things that I find when you deal with people in Washington, when I say people, I mean regulators or legislators in Washington or in state capitals, is making broad brush assumptions that what a few bad actors are doing reflects what's happening broadly within the market.
Mhm.
And so sometimes audits are actually good for the employer because an audit shows up and they look at everything and like, hey, you're doing everything good. Well done.
Mhm. Right.
Because my experience is audits are very rarely about trying to catch people.
Mhm.
Then inevitably people get caught. But
Right.
audits, as it relates to enforcement of these rules, is almost always about what are people actually doing and how does that reflect what we ought to be doing from an enforcement perspective? Where should we be paying more attention?
Mhm.
We've seen this happen on the mental health parity front over the last 5 or 6 years with some impact on regulation, but I think it's more being driven by the what's wrong and what do we need to do something different on going forward, rather than the dragnet where they're trying to catch all the criminals, right?
Right. Right. Yeah. Well, it's going to be interesting. As you said, it's been a while since we've done any of these random audits, just to see what comes out of it when it starts. It seems that this system hardening is going to be a big part of that,
Yeah.
from what I've been reading up on. So looking at all these, encryption, all these sorts of things, these are things that, folks should be doing anyways. If you're one of our clients, I know you are doing it, because we've gone through those risk assessments and flagged that for you. But for folks who haven't done it, you need a way to getting there and making sure that you have documented plans around what you've done and how you enforce that and whatnot. So I just want to reiterate that. Not saying the audits are coming for you, but it's just a good practice, and just go ahead and be proactive instead of reactive at this point.
Yeah.
All
Absolutely.
right. So one of the interesting things, we're going to move on to this big update that came in. This is the affectionately known as the SUD rule, the Substance Abuse Disorder rule of CFR Part 2, 42 CFR Part 2. And this is, we've been getting a lot of folks who are really, you know, trying to figure out what's going on. We're trying to figure out somewhat of what's going on because they're supposed to release some additional guidance, and the deadline is February 2026. And as I've seen so far, there hasn't been much in the way of guidance from OCR around this, but we do know some key changes. So I think if you want to go ahead and tell us a little bit more about this, David, and what you're seeing out there, and how you're preparing your clients and folks for this, making sure they're compliant with SUD.
Yeah. I mean, the one thing that I start with is when you go back to the formation of HIPAA, HIPAA had special rules for the treatment of mental health records. Okay.
Mhm.
And those, and broadly, mental health treatment had special requirements. You and I have talked about this a million times, where if you're, go back to the access to record stuff, there are restrictions about how much a patient can necessarily see of their psychiatrist notes about them.
Right.
And that's because sometimes those notes can add to the condition, right?
Right.
but it's one of the realities because of the nature of substance abuse use disorder is that it's classified under the DSM as a mental health condition.
Mhm.
And you've seen a lot of action at the national level to broadly bucket both mental health and substance abuse treatment in the same kind of parity language. But
Right.
one of the things that came out of the CARES Act was to allow substance abuse disorder to be treated slightly differently than mental health records. And so what was happening is a lot of substance abuse disorder records were not being accessible or disclosed because of the mental health treatment restrictions. And so, one of the things was driven towards, making sure that they're being properly maintained and protected. But then some of the stuff was about, hey, we're going to take our pocket universe rules that say mental health records have to be treated differently than other medical records and saying, we're going to start thinking about substance abuse records being treated more like regular medical records and less like mental health records. So one of the things that we know exists today is, what we call TPO, where there are easier ways to exchange information without consent for treatment, payment, and healthcare operation purposes. And
Right.
so one of the things that's come out of this is an effort to simplify the way for that consent to happen, and then to allow, once it's been consented, that they can be redistributed in accordance with regular medical record HIPAA regulations. Does that make sense?
Yep. Yep.
And so,
Go ahead.
one of the operational changes is that the notice of privacy practices needs to reflect that substance abuse records will be treated differently than other mental health records. But go ahead.
Yeah, no, I was going to say it might be helpful to discuss, with the TPO, at what point would those mental health records be restricted for in a TPO situation versus a consent situation with an individual. So maybe with a caretaker or something like that, so that we're a little bit, maybe that might help with folks with some clarity around those items.
So, as a general rule, for example, you're not really allowed to disclose mental health records even to third parties. And there are very strict rules about how they would even consent to disclose it to someone's other medical provider. So, for treatment purposes, or even the degree to which they're disclosing all the information for mental health treatment as it relates to payment purposes. But now what they're saying is with substance abuse records, you've got more flexibility. We're not going to restrict that as much in terms of treating it like all other mental health records. We're going to treat it more like it's regular medical records. But then also maintained certain rights as it relates to restricting the disclosures and prohibiting the use of those substance abuse disorder records to be used in any kind of civil, criminal, or administrative procedure without a court order or patient consent. Each of these are lining up to really treat substance abuse more like a regular medical condition rather than as a type of mental health condition. And that includes changing some of the penalties to be more like HIPAA penalties rather than some of the tighter criminal penalties that were necessary out there. And then, I think the long term is about saying, we're going to treat substance abuse more like a medical record, less like a mental health record, but you need to make sure that people understand that this is changing.
Right. So with that, the key changes that we're sending out and working with our clients around is, and just to sort of summarize, is making sure we have those updated NPPs, which for any folks here who are total HIPAA clients, you have received those updated NPPs. There are updates to policies, to your privacy policies and procedures, talk about how you are handling the substance abuse records. And
Yep.
then there's the disclosure form that needs that additional box. So not only do you have that for mental health records, HIV status, and then there's also now for sub records it has to be distinct. Now you can say I'm going to release everything, and you can sign that off also, but the form does need to include that specific, and also have a time frame that is available for that disclosure. So that can expire within a month, could be a year, could be indefinite, but you need to make sure that you're clearly delineating that for the folks. Is there anything else there that I missed?
I don't think so. And I think I saw a question pop up about this particular topic. And I think what I would add to that is, we're staying on top of it.
Mhm.
One of the things that, and again, don't hear this as political commentary. It's just more kind of just the reality of what's happened. There have been at least significant delays in getting some President Trump's appointees through the Senate and available for them to do the policy work that they're allowed to do. And so sometimes what we're seeing is, hey, we're going to do something about this, and it gets thrown out there. And then the person who's actually going to be charged with doing that work comes in and disagrees with it. And so I feel like there are certainly things like this that you just got to be mindful that we're going to keep you up to date and share that with you when we see the actual decisions. But that, like you, we're at one level kind of waiting to see, because unfortunately, the one thing that has become crystal clear to me over the last few years of my life is that the second you start assuming that you know exactly what's going to happen on some front is usually the point in time where you get corrected for making that assumption. And so, we see things change, and we try and communicate it to you as soon as we see it. But even I've had a couple examples over the last year where somebody has said, well, I think this is what that means. And it's like, yeah, I think that's pretty clear what their intention was. And then you get some additional guidance out of the administration on it, and all the things that you assumed that meant weren't necessarily what that meant. And so we're trying our best to figure out what people mean as well through these processes.
Yeah, we're making our best assumptions, which we all know when you assume things.
Yeah, that's right.
Great. Well, I appreciate that, and yeah, just to reiterate, as we get more clarity here, we're doing the best we can with the limited amount of information we have. So I wonder if this compliance deadline might change, or with the work we're doing. We have added that information. So again, if you're not a client of Total HIPAA and you need help with this, feel free to schedule a clarity call with us, and we can help you with this and get you compliant with what we know so far. Okay.
I think that's an important point, which is, the one thing I think people are making mistakes out there. If I see anything in particular, it's this, well, I can figure it out. And what I'm finding time and time again is that our efforts, our belief that we can figure out what somebody means in this process is biting us more often than not. And so just be mindful. Part of the reason that you exist, and the reason why the work you're doing is important, is that oftentimes we're backing into what they meant by having to reread what was actually written. So that's a reason for having a good partnership and the work that y'all are doing. So
right. Thank you. I appreciate that. And yeah, it is. We always talk about HIPAA being a process, not a destination. You're never going to get to a point where you're going to be done with HIPAA compliance. You're going to be done with compliance in general. It is a moving target with changing technologies, changing laws, changing interpretations. And so you need a team that's going to help you sort of navigate that landscape. We have, and this comes up a lot, and I want to talk about it from the standpoint with you, David, from a regulatory standpoint, and some things to think about. Just a heads up, everybody, in March, end of March, and we'll be sending this out, we're going to be doing a webinar solely on HIPAA compliance and AI, and the ins and outs of it, how to configure things properly. We're going to have Rob Chubbuck on with us, who's one of our frequent guests around that. But just sort of as a teaser for you guys. But David, I wanted to talk to you about this, and this is something we run into a lot with folks trying to make the AI decision. Are they going to allow it within their systems? And a lot of times they're just turned on, without any knowledge. Like we see it with Apple Intelligence, just turned it on for, in the OS is natively. We see it with Android having Gemini available within their phone natively, and what we're looking at and how this is driving our IT friends up the wall with all this information that's being shared. So I'm going to just let you start talking here.
Well, I'd say this. You know how you whisper to people,
Mm-hmm.
and how loudly you whisper almost always impacts how much anybody else hears it, right? Ultimately, the reality of AI is this. Unless you've put restrictions in place, whatever you put into AI is being used to make that AI system better, which means you should have no privacy expectations about what you put into it.
Right.
And this is, there's a reason you feed scraps to chickens, because they're going to eat them. There's a reason why AI companies have left their large language models out and available for people, because whatever you put into them is making them smarter and making them able to do the things that they want them to do. But that also means that whatever information you put into it is being retained within that system.
Mm-hmm.
And so it goes back to the things I feel like you and I talk about, Jason, all the time, which is, do you have a business associate agreement? And do you have the right kinds of protections around that to make sure that that information is not a problem going down the road? Is
Mm-hmm.
it not good? Is it going to be a problem that somebody has it? And
Right.
it seems like so many of the conversations that we've had have been around cloud computing vendors who didn't want to sign a BAA, right? Well,
Right.
This is the place where you've got to understand having a business associate agreement and being careful about what you put into the system is going to be a bigger and bigger deal. We actually had within my company a recent, kind of company-wide conversation about, things that are going on, and 10 minutes was spent on, we have a relationship with Microsoft's, AI platform, and that means you can take client data and dump it into that and get output and not have a problem, because we've signed a contract with Microsoft for the use of their product, and therefore you can put PHI into that because it's not going to go outside of our portion of our relationship with Microsoft.
Right.
And then the next words out of their mouth were, that means don't do the same thing with ChatGPT
Mm-hmm.
or Anthropomorphic or any of the other AI companies, because we don't have similar protections in place for that.
Right.
And it's a reason why, your point about both the policies and procedure, the temptation to just say, I really like ChatGPT and I use it for all these other things at home. So, I was getting ready to prepare for this presentation, and I had 47,000 pages worth of claims data, and I just jumped it into ChatGPT so that I could give me some analysis on it. Well, that's a problem.
Yeah.
And so you want to make sure that you've got the right kind of contract and that you're avoiding the downstream problem. We already see AI starting to show up in a couple other ways in the medical space that I think is important. I read an article yesterday about doctors' offices. Now, the doctor's not taking notes. They're not sitting at the computer typing stuff in while they're talking to you. The doctor's talking to the patient Meanwhile, some device in the room is collecting the conversation and then converting that into the medical record.
Right.
And in that situation, my hope, my prayer is that that practice has signed a BAA with that device and their technology to make sure it's restricted in terms of where it goes outside of their footprint. But that's the only way that can happen. Without having that piece, I am, it's going to be one of those things where, Jason, last week I was telling somebody about AI and what it was doing. And I said, well, we have to recognize on the agent broker side, and frankly, I think we have to recognize throughout the market, is that fear of AI and what AI will do with the information that it has is getting to a societal, a broad brush societal concern. And I think you're going to start hearing more discussions about what Washington ought to do about it, what states ought to do about it. But the paranoia of some reminds me very much of the paranoia people have about HIPAA, right? And I don't want my medical information going anywhere. Well, you can't restrict that. And so it's one of those things where I would tell you, regardless of what kind of, what party or what kind of category you fall into today, whether you're a covered entity, a business associate subcontractor, or one of the above, depending on what day of the week it is, you need to be very mindful about how AI is being used, not only by you as a company, and making sure that you have business associate subcontractor agreements in place, but also to make sure that your employees aren't using it to do their jobs, which sometimes you want to have happen, but can create problems for you.
Yeah. Yeah. I mean, that's one of the big things we're running up against is that shadow AI usage. Is a company may have said, we're going to allow Copilot or Gemini, and then they turn around and they find out that employees have been using that Chat GPT or something else. So it's really important that folks, you guys go in to these discussions with open eyes and open minds as to what this is being used for, how this is being used, and what kind of data is going in there. And it's
sorry, I could not get Copilot out of my brain a minute ago, and I was thinking about Microsoft's products. So
oh, you're good. You're good. There's so many out there right now that it's just And
Copilot just seems like such a, again, typically Microsoft, but a vanilla kind of term for this too. It's like you'd expect it to be like something else, tech heavy, and it's like Copilot.
Right.
Okay.
Well, the other thing, and I didn't put this in here, but I want to really caution people who are using this, is you make sure you're double checking what comes out of these AI agents, because the hallucinations are real. That the information that's coming out is not always accurate. They'll make up cases. They'll make up, references to things. I heard a hilarious one the other day that Conan O'Brien was listed on Netflix as being this new Star Search, and he was listed as a previous winner in Star Search. It turns out he had never been on Star Search, but somebody had written an article that said there were more people with more talent on Star Search than this guy, and AI read that as he was on Star Search, and somebody didn't check it, and it made it onto the Netflix basically, and his lawyer came in and talked about it, and it was a fascinating conversation, things I never thought I would learn from Conan O'Brien, but it's worth a worthy question or worthy thing to keep your mind on and keep your eye on, is that making sure you're double checking what's coming out of these systems and that you're really proofing what's happening.
Yeah, I mean, I had that conversation with somebody yesterday where, my comment was, hey, I know that your brother is interested in working for us, and he's worked here for a long time, but he needs to do a resume. I don't think he's ever done a resume. I was like, well, my new trick is I want them to go into ChatGPT or Copilot or something and go through the process of writing a resume. And I said, I want them to do that for two reasons. I want them to make sure that they're comfortable with those products and those tools. But I said, honestly, the other thing I'm checking is, did they proofread it after they did it? Because
Right.
that failure to proofread is the piece that is honestly embarrassing people left and right.
Yeah.
And, that's the place where AI is like any other tool. Would you put a hammer in the hands of a 5-year-old? Would
Right.
you want to make sure people understand what it can do, but also what they shouldn't assume that it's always doing. It's not yet, it may be, but it's not yet as smart as a human. And even when one day it might be as smart as a human, the question is, which human?
Right. Right.
And so if it's as smart as the dumbest one of us, then what are you going to get out of that? Not great stuff.
Right.
So.
Yeah. So, well, look forward. We look forward to getting into more depth around compliance and whatnot in March around this. But we're gonna move forward because we have a couple more things to wrap up here, and we just got a few more minutes here with you, David. And I do want to make sure we get time for some questions here. Important deadlines coming up here, folks. This is the time to start reporting any breaches you had under the rule of 500. So any breaches of 500 individuals or more, you needed to report those within 60 days of them happening. But now is time to report any of those under 500. So this is a very important deadline. This happens on March 1st. This is always every year. So we just like to remind folks, if you have specific questions around this or need help with this, and you are clients of Total HIPAA, reach out to us. We're happy to help with this. If you're not a client of ours and need help, we can get you into a plan and help you file these breaches. So we want to get those filed. This is very important, and we need to make sure that we get those filed. And this is the law. I don't know if you want to say anything else about that, David.
Well, and I just say this: keep in mind, this is the part where you're basically now telling HHS that you screwed up. But by the time you get to that point of doing that report, you should have already, done all the other stuff you're supposed to do around a breach. So don't have skipped that either. Make sure you've done the breach investigation, et cetera, et cetera. So.
Right. And make sure you've documented that. Again, if you need help with that, reach out to us. We're happy to help with that. That's part of the services that we offer. And we've got just about 6 minutes left here, and we've got some questions here. We've got a bunch of interesting ones here. So first off is, what is the risk to an employer with a level funded plan with no FSA or HRA? They genuinely feel they have no access to or management of PHI.
Okay. So what I would say to that is, if they don't have access to PHI, then they're probably not fulfilling their duties, because a level funded plan is a self-funded plan. And the only exception for HIPAA compliance, there's limited in compliance responsibility when the group is fully insured. But when a group is under 50, self-funded, and it's self-administered, then they don't have to worry about HIPAA. But again, I'm not aware of a single level funded plan out there that's being self-administered. And so the fact that they think they have no access to data does not mean they actually don't have access to data, and they have to be fully compliant. It's one of my tried and true rules about level funded is that level funded is self-funded with complications, and this is one of them.
Okay. So it sounds like they just haven't looked hard enough or looked deep enough. Agree?
Well, they have access to it. I mean, the main thing is they might not be looking at it, but they do have access to it.
Right. Right.
And if their broker's looking at it, then their broker's acting as a business associate, which makes them a covered entity.
Right.
So
there we go. All right. Question about the mandatory use of MFA. As a current client, Total HIPAA flagged an email as an MFA method. Do we need to update all MFA away from email? If certain websites only allow email, is that okay? We have at least some MFA. What are your recommendations? Email is not your best MFA. I'm going to jump in on that to start with. But David, what are your thoughts around that?
Well, I mean, I would say that, I'd say this. The problem with email is almost always about who can access it, and the situations where someone can actually spoof an email address and beat MFA by using the email address, which sometimes how they started with the process to begin with. I'd agree that as a general rule, text and or biometrics are going to be a far better method of multi-factor authentication rather than email, because it's a lot tougher to be able to spoof a phone being somewhere else as opposed to someone hacking an email address, getting that email code and using it. So again, I don't know the specifics of the situation, Jason, so I'm sure there's more details to it than you shared than I know. But I would say email is okay, but discouraged because it's a hell of a lot easier to hack than biometric or text.
Yeah, and I think that's our general stance here is we really want you to move towards the text, the biometric, pass keys if you can.
Yeah, pass keys.
Yeah, which has the MFA built in, and that just adds that additional layer and is practically unhackable. I mean, I guess there are ways around it but as far as sharing passwords and whatnot, it gets you in a much better security stance. And I think we've put some stuff up around that. So if you guys just do a Google search around some blogs that we've done with that, you can see more about passkeys and how great those are, and how helpful they are.
And what's interesting about the passkey side is there's a lot of cool things out there from, I use Dashlane, but even authenticators that are using and creating authentication keys. We quickly moved away from the idea that we're all going to have little tab keys that we would put in our phones or computers, and now it's almost all software driven, but it's still largely biometric or some other type of driver to make sure that it's actually the right person they're talking to. Sorry.
Right. Okay. Can covered entities require BAs to not use AI as a part of their contracts to protect against the use of AI with PHI? That's an interesting question.
I mean, I would say this: you can certainly, as a covered entity or as a business associate, put in your BAAs or BASAs whatever you want on that front. The question's always like, how many people are going to actually agree to it? And what do you do when somebody violates it anyway? Or like might happen in your office, somebody does it without you necessarily knowing about it.
Right.
And so what I would encourage you to think about on that front is, if you're going to use it, make sure that you've got all the back end protections that you need. And then don't just assume that they're going to do what they need to do, that you need to make sure that they're doing it by checking up on them.
Right.
So.
Wonderful. All right. Well, our last question here is, will the presentation be sent to the participants? Yes, it will. We've recorded this and we're going to send this around to everybody. And with that, David, thank you so much today. We got you guys out right at the top of the hour. If any additional questions come up, please feel free to reach out to us. And any questions we didn't get to, we will make sure we send those around to folks, and we will email those folks directly. But again, thank you so much, everyone, and have a wonderful day. And we will talk to you soon. Thank you.
Thanks. Bye, guys.